Thank you. We have time built into our program this evening for questions. We have a reception down the hall, but our plan is to start that at 7:15. Please ask what questions you may have to our guest.
If any.
And if you could stand up, please, and identify yourself.
The question was, what were the plans of our office that relate to cyberbullying? First of all, there are instances where cyberbullying can amount to a crime. When the internet is used to threaten, annoy, harass another individual. And those are and can be prosecuted as criminal cases. But I think where, in fact, we are most active in this area is in crime prevention. Now, somewhere here tonight is David Suchman. David Suchman is the head of our Cybercrime Bureau. David was an assistant DA in Manhattan, went on to be a child exploitation prosecutor for the federal government, worked as the head of consumer affairs for the governor of New Jersey in the Attorney General's division, and we were very lucky indeed to have David come to us to head our cybercrime division. But what I like so much about working with David is that he is not only a superb investigator in the complex cases that we deal with and in managing the more routine, but he spends days each month going out, and we ask other assistants to go out with him to schools. We talk to parent groups. We are in the community advising parents on how to deal with cyberbullying, talking to kids about the consequences of cyberbullying. So we have limited laws that in instances can be used to prosecute, but I really believe that the broader role that we have here is in our ability as prosecutors to talk meaningfully to communities about cybercrime. Now, David recently was at Stuyvesant High School, and I was not there, but it was reported to me by somebody that was there that when David talked to the 800 kids, young kids who were there listening to him talk about the consequences of cyberbullying, you could hear a pin drop in the audience. People are very tuned into this issue. We've seen tragedies just in our region, over in New Jersey, when we are dealing with cyberbullying that may have led to suicide. So there's lots we can do. There's some enforcement we can take, but we take it all seriously.
My name is William Brand, former assistant district attorney years back. I've always been a little bit distressed that the public is very excited in the prosecution, and once the defendant is convicted, loses all interest. And I wonder if maybe the district attorney doesn't have a little responsibility to concern himself with corrections to prevent recidivism, which nobody else seems to be paying any attention to.
It's a great question. I think, without changing the question, I think it was a comment that prosecutors seem to be more focused on getting convictions and not on the consequences in terms of reducing recidivisms as a result of those convictions. And let me tell you that I agree with you. And I actually expect that many people in the audience also agree with you. My philosophy is very simple. And perhaps it's informed, having been a defense lawyer for 20 years before I became the Manhattan District Attorney. And that is, we need to keep our eye on what reduces crime. I'm guided by two questions in everything I do as DA. Does it make us safer, and is it fair? And we should not just be, as an office, counting our convictions, but we really should be employing those practices that are proven statistically to make us safer. So in the appropriate cases, we certainly use alternatives to incarceration in order to do the best we can to make sure that the defendant is given the treatment to minimize the chance that he or she comes back into the system. We'll have this January, or very close to this January, a mental health court in Manhattan, working in partnership with OCA, because we recognize that so many people coming into our criminal justice system have mental illness. and that what we need to be focused on is not just the criminal act itself, but trying to change and provide behavioral change using sticks and carrots that we have and judges have to reduce the chance of recidivism. For ex-offenders, I absolutely believe that we have a responsibility as a society to address what happens to people who come back to the communities after they left state prison. And I have that belief because it's simply a matter of common sense and making us safer. If someone comes out of state prison, they have a roughly 2/3 chance of being back in state prison within 3 years if we provide them nothing more than a bus ticket and the clothes on their back. But we know, looking around the work that's been done in New York State by some of my brother district attorneys and sister district attorneys, that if we are thoughtful about reentry programming and providing appropriate help where we can to ex-offenders, we can reduce that recidivism rate dramatically. That makes our communities safer, and I believe it is fair, and that's why I support it. And when I became DA, I brought into the office someone who's known to many people in the room, Chauncey Parker. Chauncey Parker was a former Manhattan assistant, a former assistant United States attorney, was the head of the Department of Criminal Justice Services, and his job and his title in my office is Executive Assistant District Attorney for Crime Prevention Strategies. He spends every day not just looking at what we do in the courtroom, but how we as an office can use all our tools to drive crime and recidivism rates down. That makes us safer, and that's why I think it's the appropriate role for a DA's office.
The New York Times recently reported on the acquittal of an African-American record producer, Clarence Jones, on resisting arrest and interfering with police. Your office tried to secure a plea from him, and he went to trial. My question is, and he claimed that he was arrested only because he filed harassment charges with a state senator against police. My question is, to what extent does your office try to independently investigate police charges rather than act as a rubber stamp for police arrest?
It's a great question. For those who didn't hear it, I think it's boiled down to, do we rubber stamp what the police bring into our office by way of charges, or do we conduct an independent review? Every case that comes into the DA's office that is the result of a summary police arrest is reviewed by an assistant district attorney. And that occurs principally in what's called the complaint room in our office. It's a process that I went through as a young assistant DA. Every police officer who swears out to the complaint is interviewed. And in many instances, we, after doing the initial investigation, we may determine the charges we believe are appropriate at the inception. We may dismiss charges for either legal reasons or because we don't think a crime is made out. Or we may elevate the charge if we believe that police have undercharged it and we do additional information. So we have what I believe is a thoughtful screening process when cases come into our office. We can always do a better job. And I am working with the head of our Conviction Integrity Unit, Bonnie Sard, to make sure that we are providing checklists and other best practices to the young assistant district attorneys who screen many of these cases to make sure that the cases, as they come into the office, are screened as rigorously as they can be. And I believe that's good for a number of reasons. One, because it weeds out the wheat from the chaff, sorts out the wheat from the chaff. And secondly, the cases that survive that process should be stronger. But we do have a very thoughtful screening process. Some cases that go to trial result in acquittals. That is the nature of the work that we do. And it's the nature of the jury system which we are privileged to operate in. And so I respect the jury's determination in those cases, and I don't second guess it. Any other questions?
Hi, Marcus Corleo from the office from 1998 to 2006. I have a question about the guidelines that your office recently issued with regards to prosecuting corporations. As you probably know, it's very difficult for an attorney to determine whether her client should self-report. It takes huge weighing factors, and it's often based on prior actions by your office with regards to whether or not it's worth self-reporting. In the event that it's not feasible or not recommended to self-report, how much credit does your office or will your office give to corporations for hardy compliance programs that are in place within the corporation?
Well, we certainly will look at a number of factors, and that will be one of them, just as you would, just as a federal court would, and just as a federal prosecutor would. I think any lawyer who is advising, who's able on the front end to advise a corporation of any size, it would be to make sure that there's a compliance program in place such that if criminality occurs, it will be hopefully against the best efforts of the corporation, and that, of course, is very material to any prosecution review of corporate criminal liability. So it's very relevant, and also Adam Kaufman, who's here, who's the head of our investigations division. I'm sure that Adam would, to the extent that I haven't fully explained the answer, which is certainly possible, I'm sure Adam would be happy to talk with you and fill it out further for you. Any other questions? Yes.
There's been a bunch of high-profile arrests in the insider trading area by the U.S. Attorney's Office for the Southern District. To what extent is the DA's office also looking into insider trading involving the use of expert referral networks? And to what extent is the DA's office using Wiretap, which seems to give a lot of evidence in these cases?
I can't comment on ongoing investigations and specifically what we are looking at and even what we're not looking at. But I will tell you that I sign more Wiretap applications than I can believe. And I don't say that in a frivolous way, but we are very aggressive in presenting to a judge applications for eavesdropping in a whole range of cases, from white-collar crime to cybercrime to organized crime. So we use all the tools in the tools box, and I think every sophisticated modern prosecutor's office recognizes that in white-collar crime, a wiretap that is justified can be extraordinarily effective in gathering the information that would otherwise be available. Anything else? Thank you so much, everybody, again. It's great to see you.
I want to thank the district attorney for those excellent remarks, and more than that, the excellent work that he's doing for all of us.